Morning. Welcome to the First District Court of Appeal. We have one case on our docket this morning. That is Merkley v. Stark, HMA et al., which is our case number 21-3555. Counsel, are you ready to proceed?
Yes, Your Honor.
Okay. Proceed when ready. Before you get started, would you like to reserve some time for rebuttal?
3 minutes, Your Honor.
Okay. We'll have 3 minutes for rebuttal then. Thank you.
May it please the court. My name is Al Bachrach. I'm here representing the appellant, Mr. Merkley. This is not a failure to diagnose case. It is a medical
Can I trouble you to pull the microphone a little closer to you?
Absolutely.
Thank you.
Is that better, sir?
Thank you.
I believe I just said that although this is a medical malpractice claim, this is not a failure to diagnose claim because at the relevant time period, the underlying issue that led to Mr. Merkley's amputation had not occurred while he was under the care of the defendants. And it's not a surgical negligence case where some procedure was performed in a negligent manner below the standard of care or that some object was left to the side of the surgical patient. This is a claim that arises out of the evolving standard of medical care with regard to diabetics. The record clearly establishes that at the time period in 2017, Mr. Merkley was a 38-year-old type 2 diabetic, poorly controlled, when he showed up at the hospital in Stark. He was there for 3 or 3.5 days and discharged on the 4th day. It wasn't until days later that he had an abscess that ruptured at home. He went to North Florida Regional Hospital, and then days later, after his care at North Florida, he underwent a below-the-knee amputation as a result of wet gangrene triggered by osteomyelitis. None of this had occurred or was not diagnosed while he was under the care of the appellees in this matter.
Well, can I back you up a little bit? Sure. As I understand it, around the time of the amputation, maybe November 27th of 2017 or sometime within a couple of days of the amputation, a nurse assistant and treating physician both supposedly told him that, had you gotten some antibiotics earlier, this amputation wouldn't have happened. Wasn't that sufficient notice under Tanner v. Herzog for the statute to start running?
We are here today arguing no, although it appears on the face of the record that it would be an easy decision to make.
Well, how are you getting us to try to look beyond the record?
Well, it's clear that Mr. Merkley, the appellant, has conflated all the information that he's learned over the years with regard to his claim and to his medical treatment, and then stated, both in an interrogatory answer, which he specifically changed to say that, and his testimony with regard to his deposition by the defendants, that a nurse's assistant told him that he wouldn't have undergone the surgery if not for medical malpractice, and that the surgeon himself told him that he would not have undergone the amputation but for the medical malpractice of the appellees. But that, as I argued to the circuit court, that just doesn't make any sense. First of all—
Okay, so where in the record? We're on summary judgment, right?
We are.
We're reviewing a cold record. Where in the record is there some contradiction of that?
The only contradiction of that is the argument that the plaintiff, appellant, has conflated all this information.
But he didn't even submit, there's no affidavit from him even conflicting his own evidence, right? I mean,
Well,
that would potentially be improper, but there is no contradictory record evidence from Mr. Merkley saying, I was wrong when I said the nurse told me that, or I misunderstood, or anything like that, right?
Your Honor, that's correct. That was in fact part of the argument at the hearing on the summary judgment, that you can't fix the client. You can tell clients what occurred. You can tell clients how to testify. You cannot tell a client that's convinced that they're remembering correctly that they can't testify as to what they believe is true.
Well, I mean, I hope we're not telling witnesses how to testify, but let's go back to it's a subjective and objective test that triggers the running of the statute. Under that bifurcated analysis, he knew, pursuant to his interrogatory responses, or wouldn't a reasonable person have known that there could be a potential medical malpractice claim right around that time?
No. A reasonable person wouldn't know. It's probably not anything that even an attorney well familiar with medical records would pick up on, because the medical records from the defendant at police don't have any information that would lead a reasonable person to believe that their care fell below the standard of care, just reading the records, and that therefore he, meaning Mr. Merkley, ended up at a hospital having a below-the-knee amputation. It wasn't until a hospitalist, reviewing all the records, gave an opinion that anyone would have a reasonable belief that malpractice occurred. And that opinion was not that the care that he was given by the defendant at police was incorrect, but that in the evolving standard with regard to treatment of diabetics who are a known
Well, I mean,
risk.
aren't you changing the standard? You're sort of asking us to change the standard from what the plaintiff should have known or knew to now it's triggered by expert testimony.
Well, I am actually saying that, so that's true, but I'm not saying that the standard changes. What I'm saying is that an unsophisticated 10th grade dropout like Mr. Merkley has no ability to connect the dots in this case.
Well, I understand that had there not been the testimony about the nursing assistant and the treating physician, just, poor guy's foot has to come off. He didn't get it, assuming he didn't get an explanation of why, or, that there may have been some problem with the previous physicians and their standard of care. I'm with you. But once the nursing assistant and other people say, hey, if we got you some antibiotics earlier, this wouldn't have happened, or rather the other people got you some antibiotics earlier, this wouldn't have happened. I mean, even for an unsophisticated person who hasn't done any investigation, I mean, doesn't the clock start then?
No. Mr. Merkley was given antibiotics prior to appearing at North Florida Regional Hospital, which is where the amputation took place. The day prior to seeking care from the defendant at police, Mr. Merkley had stopped at a freestanding medical facility in Marion County on his way home, and they had given him a shot of antibiotics and sent him home. The next day, when his foot was still bothering him, he called the 911 number. They transported him to Shannon Stark he received antibiotics at Shannon Stark from one of the appellees. It's not a question of whether he was given antibiotics at Shannon Stark. The real underlying medical issue here is, in addition to the care that he did get, should he have been given prophylactic care by the defendant appellees by being kept in the hospital and placed on IV antibiotics? Now, that is a fairly sophisticated concept with regard to medical care, because it's not saying that the care given was incorrect. It's saying that a better course of treatment than discharging him on that fourth day would have been to keep him and then put him on IV antibiotics and keep him another 2 weeks.
Well,
that's it.
That was good.
But that's exactly what he says in the interrogatory that he knew about at the time, though, the IV antibiotics, right?
He does, but again, that goes back to, and I understand it's the elephant in the room, it's a major problem here, but he did not know that and could not have known that because that information wasn't available for another 2.25 years. So no one other than Dr. Goldstein, I'm sorry, I was searching for a name. No one other than Dr. Goldstein has ever said or written that with regard to here would be the proper course of treatment. And Dr. Goldstein's opinion isn't in 2017, it's not in 2018 or 2019, it's not until 2020. So it's not until 2020 that Mr. Merkley is actually told what the theory of the case is going forward. Prior to that, Mr. Merkley, no one had an actual route forward, like what you would do with this case, because a review of the evidence from Shannon Stark and the doctor's notes at Shannon Stark, the other two appellees, all make sense to a layperson. I mean, I've read a lot of medical records, but I didn't go to medical school. I didn't pick up on anything. I know that my client, with his 10th grade education, didn't pick up on anything. So what we're dealing with, in my argument, is what do you do with someone who has conflated information across time? We're all aware that witnesses, even eyewitnesses, get things wrong. You know, they identify that man as the person that did whatever it is, and in fact, later or other evidence shows that the identification's incorrect. People over time conflate what they actually know with new information, and then they tie it together in their minds, and that's what Mr. Merkley did in this case. He tied together the information from 2020 and insists, and probably if we had him here today, he would still insist that they told him and that's what happened. But they could not have told him as a matter of actuality because nobody knew that. There was no such information available. A nursing assistant clearly wouldn't know the evolving trends in hospitalist care in the United States. That just seems like a given.
And counsel, you're well into your rebuttal time.
Oh, I'm sorry, Your Honor, I saw the yellow on it.
Yellow is
I'm
rebuttal.
going to stop.
Okay, thank you.
Thank you.
We'll reserve the remainder of your time.
May it please the court, Dinah Stein on behalf of Doctors Ibrahim and Ristia, and I have conferred with Mr. DeLugo, who represents Shands, and he's been kind enough to give me all the time so that we don't have to split the time. So with that, I will quote the trial court judge during the hearing who said, you know, the evidence here is just so one-sided that I feel that as a matter of law, I have no choice but to grant summary judgment for the defendants. To be clear, the plaintiff did not submit any counter evidence to the motions. There was an affidavit filed out of time by the pre-suit expert. The plaintiff did not take any issue as to the arguments, the calculations. The only issue was what the accrual date is. And all the judge had before him were the sworn interrogatory response and the deposition. Now, to be clear, the interrogatory response, that is a standard Florida interrogatory. It is the same interrogatory that was the grounds for the summary judgment in the Ondo versus Gajewski case. And in the deposition, Mr. Merkley was unequivocal, and frankly, whether he be educated or not, he was quite articulate. He was able to answer questions. He was unequivocal, and he understood what was going on, and he made it very clear that he felt that in his original course of care with the defendants, he wasn't being treated correctly. He said he believed that then, that they were treating a pneumonia when he believed they should be treating his foot, which was infected, and it led to the amputation. He also went on to say in his deposition that he was told in the hospital that the antibiotics should have been given. He should have received IV antibiotics. We know that he hired a lawyer within the 2 years, so he absolutely knew, had a reasonable basis for believing that something was amiss and that he should seek counsel, Your Honor.
So let me ask you about that. So the statute has these two ways to analyze this, right? The subjective and the objective. Did he in fact know versus, or in the alternative, should he have known? And so we've spent lots of time talking about sort of both, but the relationship of those two. So, and you've sort of talked about both here too, that he reasonably should have known. Is there space in the law for us to use that reasonably should have known evaluation to analyze the in fact knew or thought he knew?
The reason, the subjective, first of all, really doesn't get us past the sworn answers, which were unequivocal. However, the trial judge did address the subjective aspect of it, and he said, let's just take these facts. He goes for treatment twice. He's sent home. The infection gets worse, and now he's in the hospital, and he loses his leg as a result. He said to counsel, wouldn't a reasonable person believe that something was wrong that should be looked into? And counsel agreed. He said, well, the way you've stated it, yes. And the judge was right. So, under these facts, we can go there. I think we're still, even in the subjective phase, it's still quite clear that there's what happened there was a trigger. The other problem with subjective for plaintiff is that plaintiff never gave the court or defendants an alternative date that was reasonable. So for instance, had plaintiff come back with sworn evidence, and I'm not saying they could have disputed what he said in his interrogatory and depositions, but let's say he said, 6 months later, I start thinking about this, or I go to someone and I think, maybe I need to look into something. We might have had an argument or something to discuss in that regard. He didn't give the court that. He just gave the court an expert opinion that was issued in pre-suit, which we know from Tanner is not the right standard. Tanner said, we look at possibilities, not probabilities. And can we imagine if the standard was, we wait for an expert in pre-suit to say, more likely than not, or probably I believe. The other thing I'll point out about that, as far as the expert's theory as to what happened is the exact same theory that was not only pled in the complaint, but which is what Mr. Merkley said he believed back in November of 2017, and that is, I wasn't given antibiotics when I presented to Shands and was treated by these doctors. So the expert may have added some medical terms, he may have talked about imaging studies and osteomyelitis, but the theory is the same, and that is I wasn't treated properly when I presented at Shands with the foot issue. So, again, we go subjective, objective, it all goes back to, this record. plaintiff didn't give the court anything else to hang its hat on. All it had was his admissions. And his admissions, again, they were unequivocal. He understood. He said he believed it even when he was, before he had the amputation, and the amputation hammered it home when he was told by the medical providers he should have been given antibiotics, and that could have avoided the amputation.
Look, if I may, let me ask you about something a little different. The 90-day extension under 766-104, what effect, if any, do you think that has on the timeliness in this case?
It certainly extended, are we talking about the automatic extension?
Yes.
So it certainly extended the statute of limitations for the purpose of pre-suit. Had he not filed that, we wouldn't even be talking because it would have been just late. The 90-day extension was served, I think, a little dangerously on the last, or the 90-day extension was served on time, no question. The 90th day, though, is when the pre-suit was served, and that was, risky, but I think plaintiff got a potential life preserver there with the Supreme Court's decision that came out recently, which said if it's served before the 90 days runs out, you're fine. So I think with that, he was fine, but he was out of statute of limitations at that point. And that's critical because that means that when pre-suit ended, he only got 60 days. That was all that was left, and it's an easy countdown to when that 60th day was, and it was prior to the filing of the complaint. So that the automatic extension certainly helped. It did because the complaint or the notice of intent was filed after November 27th of 2019, but it doesn't save the day.
Well, and I think as you pointed out, that's not even argued really, so that may have been preserved below, but these extensions are not before us, right? I mean, the only issue here today is, did he know only when Dr. Goldstein's, affidavit came out, or did he know back in 2017, right?
Absolutely, Your Honor. They're not before the court. They were not made before the court below. They were not raised as an issue. They have not been addressed in the plaintiff's brief. So plaintiff never took argument with the fact that this was out of time if the accrual date was at the time of the amputation. That was the only issue argued below and on appeal, is what is the accrual date? And the only dates this court and the trial court had were the date of the surgery, which was pursuant to his admissions in two sworn document and a deposition, and the affidavit, which was served out of time, and we just know as a matter of law from Tanner is not sufficient. The court had nothing else to go by. So just with that, as a matter of law, as the court said, it had to enter summary judgment because he said, this is my record. You haven't put any counter evidence before me. I have to believe what the plaintiff said in his sworn testimony, in his interrogatory. And, there was an admission in appeal and below that if that's the accrual date, this case is over. I mean, the statute of limitations has run.
How much knowledge does something have to be discovered or should have been discovered? I mean, if, the person there sweeping up your room says, oh, had we gotten you antibiotics, you wouldn't have lost your foot. Is that enough? I mean, if your brother, some non-medical person comes and says, hey, some antibiotics could have saved your foot, how much information is enough to the discovered aspect?
Sure. Well, first of all, he not only said that it was I think a nurse assistant, but a doctor, and he tried to identify the doctor. He thought it was the doctor who did the amputation, but he did say that in his deposition that it wasn't just a nurse. So there is that. But second of all, this is not it's not as complex and nuanced a medical situation as plaintiff wants this court to think. And the trial court understood that and questioned counsel about that, in that he goes for treatment, gets sent home, he's already concerned, then it gets worse, and an amputation occurs. And the trial court said, isn't that pretty straightforward? It's not like he was told in fact, this is opposite of cases where people are told nothing's wrong and it's natural. He was told something happened wrong. So I think that's more than sufficient. I think even if he hadn't been told, it would have been more than sufficient under these facts. Because again, there's nothing else in the record to say, I was led to believe this was natural. I was led to believe that the antibiotics were appropriate. Had there been something in the record to give a different date, perhaps we can have that discussion, but I would submit that with his admission that a doctor, in addition to the nurse assistant, told him, and in addition to his testimony that he understood something was wrong, there's just nothing else to go by, and the affidavit of the expert, in addition to being profoundly late under the rule, just isn't sufficient. Again, that's just Tanner, that it's possibilities, not probabilities. So I would submit, even without the doctors telling the plaintiff that the nature of the injury was enough to communicate to even an unsophisticated person who, again, understood all of the questions in his deposition. He was very responsive and unequivocal. That was enough to communicate to him that there's a possibility that has to be investigated in regard to negligence, and in fact, he did hire a lawyer within the 2 years. So there's just really nothing else for the plaintiff to go by. Unless your honors have additional questions, we would ask that your honors affirm the summary judgments, and thank you for your time.
Thank you, counsel.
How much information is enough for a layperson, not particularly well-educated and not medically sophisticated? Can you really logically go forward, as the circuit court did, and said, well, you were in the hospital, you had a problem with your foot, you went home, you go to another hospital a week or so later, they amputate your leg. It's like, fits together. No, it doesn't. Back about 2,000 years ago, the Romans used to say, the rooster crows and the sun rises. It's not proof that the rooster crowing makes the sun rise. Being in the hospital for some reason, being discharged, and going into the hospital for another reason just doesn't link up in anybody's mind logically. Yes, they both involve the same foot and leg, but the first time, the diagnosis is cellulitis. It's not an infection. And he's discharged because the medical consensus is that problem is resolved. And there is no other problem when he's discharged from the Applebee's hospital by the individual doctors. So you could speculate, I suppose, like they say in these cases where you have a stillbirth and you go, well, other people have full-term babies that are alive. I guess the doctor did something wrong. I had a stillbirth, but that's not the standard. The standard is, do you have information that lets you connect the dots? It's the connect the dots issue, and that's what's missing in this case. Mr. Merkley simply was not able to connect the dots, and therefore, he didn't have an infection that got worse, as was stated. He had cellulitis,
Counsel, your
and
time
then he
is,
had an infection.
Counsel, your time is expired.
Oh, sorry, I was watching it count up instead of down.
Yeah, up means expired, so.
It
Thank you
is.
both for your argument. The case is submitted. We are adjourned.
All rise.